Call the second case on this morning's docket, case number 116692, Via Christi Hospitals, Wichita, Inc., v. Canpack LLC et al.
May it please the court, I'm Ryan Welts of the law firm Wallace Saunders on behalf of our client Paradigm Management Services LLC. With the permission of the court, I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
And for the benefit of everyone watching, it's just a thumbnail sketch of what this case is all about. This is a case that arises out of a workers' compensation claim of an individual named Darren Pinion. It has to do with the charges associated with the care for rehabilitating him after a significant burn injury that he suffered on the job while working for Canpack. Canpack's workers' compensation insurance carrier was Travelers Indemnity of America, and my client, Paradigm, contracted to assume the obligation of Travelers with respect to the medical treatment to be provided to Mr. Pinion. Mr. Pinion received life-saving care and treatment at Via Christi St. Francis Hospital in Wichita, Kansas. There were significant legal bills associated with that, and this case has to do with the interpretation of the Kansas medical fee schedule that was in place during the period of time that Mr. Pinion received his care and treatment.
Let me start you out with what has been bothering me. I can't figure out how you guys are in court. I can't see jurisdiction for this case under the KJRA. The issue is the validity of this rule that was published, correct?
I believe that is the issue.
And the rule was published by the Department of Labor, correct?
It is. It's promulgated through the Medical Services Division.
But the appeal by Via Christi, the KJRA action, is from the Workers' Compensation Board, and the Workers' Compensation Board didn't publish this supposedly invalid rule, right?
That's true.
So how, I mean, you had to have thought this through because you're defending the claim.
Sure.
How do you see that there's any reason to be talking about the validity of that rule in an action that complains about the Workers' Compensation Board action?
Well, certainly the court would have the ability to take up the issue of subject matter jurisdiction at any point, and we've not had that argument before. I think Mr. Heath would probably have arguments as to why there would be subject matter jurisdiction.
Yeah, but you had to think it through, or else you would have raised a jurisdiction. I'm just puzzled by the posture of this case, because I look at the KJRA and I look at the three parts of the KJRA that Via Christi is raising, and I can't see that they're applicable to the relief that's sought.
And I'm not sure of that, Judge. I think that the question on jurisdiction is whether, on behalf of our clients, whether we would find a position tenable to stand up and say that Via Christi has no remedy under the law for what they they feel aggrieved.
Well, they might have a remedy, but we're here on this one.
Okay.
And so again, and you're defending against it. And I'm just trying to figure out why the court would have jurisdiction.
I'm not sure that I can articulate an applicable section under the KJRA that would grant subject matter to jurisdiction to be there, and certainly I would welcome anyone who joined you in that criticism to say that
Well, I realize you like the argument, but
yeah, but I'm prepared to defend it on the merits aside from the procedural aspects. But I certainly appreciate the court's concern over the who has the ability to question this and whether it was done in a procedurally appropriate way. Mr. Heath and I are both workers' compensation practitioners. I only practice in the field of workers' compensation, and I have experience with one case only dealing with a 44510J challenge on a medical fee dispute, and it's this one. And this is a fairly unique case. I think the history of the fee schedule has been explained to the court in the briefing fairly well, but it has to do with this change from the 2010 to the 2011 iteration of the fee schedule, and specifically the stop loss provision that deals with a separate pricing mechanism when you have the care and treatment of individuals that exceeds a certain threshold. So at the point that $60,000 worth of medical services are provided on an inpatient basis, excluding trauma activation and implantables, you go to this alternate pricing scenario and determine which of these two competing pricing methodologies are used to set the maximum amount that a provider can charge. And so we're here having to do with the change of one word within that stop loss provision that was otherwise part of this 232-page fee schedule that gets adopted as part of the regulation by reference. So the word at issue was that in 2010, which is the first time the stop loss provision appeared in the medical fee schedule, it provided for the greater of those two competing pricing methodologies to be used in this stop loss formula. And then in 2011, that word greater was substituted, and the phrase in that stop loss provision was changed to whichever is least. And so when my client was contemplating getting involved and entering into a contractual relationship with Travelers to assume its obligations to furnish medical treatment for the treatment that's reasonably necessary to cure Mr. Pinion from the effects of his burn injury, they looked at the published version of the medical fee schedule for the applicable year and saw that it provided for the least or lesser of these two competing pricing methodologies, used that to set its contract price, and assumed the contractual liability to pay for Mr. Pinion's treatment based on that published medical fee schedule. And so when Mr. Pinion was released from Via Christi, the billed charges were in excess of $1 million. Via Christi submitted its bill. My client remitted its payment, and the difference between those two competing pricing methodologies was about $600,000. And so we're here today to determine whether the change of that language from greater to least from 2010 to 2011 can be enforced as it is written. The Court of Appeals determined that it could not be, and we appealed from that because the Court of Appeals determination that the regulation and that the medical fee schedule did not go through the proper regulatory and rulemaking process under KSA Chapter 77, Section 415 at SEEK was not followed. The Court of Appeals specifically found that the economic impact statement criterion within Chapter 77 was not met. But the testimony from Ann Hott, who she was the director of the Medical Services Division at the time, and she was the person who was statutorily responsible for shepherding the fee schedule through the regulatory process, testified and admitted that the fee schedule did go through the entire required Chapter 77 process. And with respect to the economic impact statement, she testified that the state of Kansas has a contract with an organization, NCCI, which is the National Council on Compensation Insurance, that the NCCI looks at the proposed changes to the medical fee schedule as they are proposed and prepares the economic impact statement in order to satisfy that element of Chapter 77. Ms. Hott testified at the formal hearing that the fee schedule in its entirety was sent to NCCI, and the NCCI report was included as one of the exhibits at the formal hearing. So NCCI did look at the proposed changes to the fee schedule, and
the change, it it was included the grader in 2010, and then in 2011 it had the whichever is least language, and then it was changed again in 2012.
That's correct.
And what was why was it changed back? Was there a testimony about that, or what? It does seem odd that just for 1 year it's modified and then changed back.
Your Honor, I think that it's more than odd. It's inexplicable that it was changed in the first place, because Ms. Hott and Dr. Terry Tracy, who was the medical administrator, who was part of the
Changed in the first
statutory
place
process.
meaning in 2011.
Right.
Is that what you mean?
Their testimony was that, you know, that wasn't intended to be part of the medical fee schedule for year 2011. That they didn't intend for that change to be there, and their testimony was they don't know how it got there. And here we are today, knowing as much as we will probably ever know, and we still don't know who put it in there or why. But it was changed back in 2012 that the greater of those two competing pricing methodologies would be utilized. But what matters is that in the interim, for calendar year 2011, that was the law of the state of Kansas. That's our position, is that it was published, promulgated, and had gone through the Chapter 77 process.
So the harm here, though, Counselor, excuse me for interrupting. So the real harm here is that your client contracted with the insurance company, Travelers, based on the printed rule.
That's correct.
I mean, that's where and so why isn't your action for a mutual mistake of fact if this rule was erroneously published? I mean, that's the dog in the fight here is between you and Travelers, right?
Potentially, and I think Paradigm, probably, has some sort of cause of action for an equitable rescission of the contract, and they didn't hire my law firm to pursue those options, and so I don't know. But what's very clear here is that the contract price was alluded to on the record. That the contract price between my client and Travelers was actually less than the difference being sought here. And so if Paradigm had looked at the situation and thought that there was, the possibility of the greater of these two competing pricing methodologies being what would be used, I think it stands to reason that would have been built into the contract price, and that would have been something for them and Travelers to work out between themselves. But what I find troublesome about the decision of the Court of Appeals here was that the second line of attack on the 2011 version of the medical fee schedule as it's written is they say, well, because these changes were unintentional, it would be arbitrary and capricious to enforce them. And that concerns me as a practitioner of law, as a person who relies on the protections of the laws of the state of Kansas to live and to do business, is the idea or notion that we can throw things out because they may not make sense or may be unintentional. If Paradigm had looked at that language and thought that it was suspect or questionable, maybe their next line of attack on that would be to make sure that it was approved by the Attorney General's office of the state of Kansas, which it was, or that it went through the Secretary of State's office, and it was, or that there was testimony by Ms. Hott and Terry Tracy in front of the Joint Committee on Regulations, which there was, or that there was a public hearing and that there was notice of the public hearing, and there was, and that the advisory panel looked at it and congregated and performed the duties that they're obligated to under 44.510I and KSA 4477 415 at SEEK. Where the Court of Appeals ends up invalidating the entire thing is by saying because the economic impact statement that was prepared by NCCI didn't reference this particular change out of that whole 232-page document, then they may not have considered it, and that criterion was not met. But if you were looking at the medical fee schedule for these types of purposes to see whether you wanted to enter into a contractual arrangement within the state of Kansas, what the Court of Appeals is signaling to those people is that you can't rely on the published law or regulation that you have to dig deeper into the process, and then look at look at what the NCCI report
Are you
discusses.
making sort of an equitable argument, or are you arguing that the rule was actually in compliance with the Filing Act?
I'm making both arguments, Your Honor. I think the equitable arguments that I can advance on behalf of Paradigm is that Paradigm was not Travelers. Paradigm did not collect insurance premiums for the notion that it might be infinitely liable for whatever medical bills.
Yeah, it makes sense to me
maybe.
for you to say, hey, we ought to be able to rely on what's published.
Well, Your Honor, that is our that is essentially our argument.
And that's the equitable side of the argument. But what do we do if what was published was not in compliance with the Filing Act, which is what the Court of Appeals held?
Sure. There are ways to deal with mistakes that might occur within a regulation. If a mistake gets put into a regulation and it makes the regulation somehow...
Well, the Filing Act doesn't say there can't be any mistakes.
Sure.
I'm less concerned with the mistake than I am whether it complied with the Filing Act.
Our position is that it did comply with the Filing Act. Ms. Hott testified and admitted at the formal hearing that all of the requirements of 77-415 were met. So there's this change of the language there that she can't explain why it's there or who put it there, but the fact is that it is there.
Was there any... Did the Court of Appeals have to decide any facts to reach their legal conclusion that the Filing Act was not complied with?
I think the Court of Appeals ignored some facts to reach that conclusion, and to be respectful of the process, their argument was that the economic impact statement that is required as part of Chapter 77 wasn't met, because essentially their argument is that NCCI report does not reference this particular change.
And wouldn't that be a pure question of law, whether or not the report is sufficient to satisfy the statutory requirements?
I think that should be interpreted as a question of law in the sense of we can demonstrate, and I think there is no issue of fact. It's an admission,
so if it's a pure question of law,
that it was sent there.
What the testimony is doesn't really matter.
It probably doesn't. I think we have not had a very robust discussion about what an economic impact statement has to discuss. In this case, the economic impact statement is meant to distill the entire industry-wide effect of all of the changes that occurred to the workers' compensation medical fee schedule. So all of that information was provided to NCCI, and the report breaks it down a little bit, and then ultimately provides a cost projection of, I think, a total increase industry-wide of cost of 0.7%. But there was not an investigation into asking the NCCI to show its work in the sense of, did you consider this change to the stop loss? How did that balance out with other changes? None of that information was ever sought from NCCI, and our position is that Via Christi, as the party trying to throw out the regulation, bears the burden of demonstrating its invalidity, and that information has not been made part of the record.
Any further questions? All right, thank you, counsel.
Thank you.
May it please the court, Ed Heath on behalf of Via Christi Hospitals, Wichita. And we are simply trying to get paid for the catastrophic care that we rendered to Darren Pinion in the year 2011. The $1,048,000 bill, we received a check from Paradigm for $136,000. Appealed that payment to Paradigm, and Paradigm said, that's all you get, that's what the MSDRG allows, and that's what the fee schedule allows. So Via Christi checked with the Director of Workers' Compensation The director said, that is in the fee schedule, but it was never intended to be there. We've been contacted by other insurance carriers. They asked why it was there. We told them it shouldn't have been there, and they complied and went ahead and made the payment. So we asked Paradigm again. They said no, and we started through the Workers' Compensation Act procedure, which is the fee disputes. We had an informal hearing. That didn't resolve anything. We had a formal hearing, and the hearing officer made 68 findings of fact, included in which were findings that the fee schedule was not properly promulgated with regard to the stop-loss provisions of 2011, and that they should not be enforceable. But what the hearing officer did not do was order Paradigm to pay Via Christi the $596,000 that we were entitled to be paid under the stop-loss provision of the Kansas Workers' Compensation fee schedule.
Was
And
the
Court of
find,
Appeal, I'm sorry, go ahead.
was the finding that the rule was not promulgated in conformity with the act a finding of fact, or was it a legal conclusion, or mixed?
I think it was mixed.
What was the factual portion of that finding below?
The Rules and Regulations Act requires an economic impact statement, which provides for the description of the costs, the persons who will bear the cost, and those that are affected. And factually, what troubled the hearing officer was, even though in the 2010 fee schedule there was a discussion at the advisory panel, the NCCI analysis had looked at what the cost would be for the stop-loss provision. The testimony before the Rules and Regulations Committee included discussion of the stop-loss. For the changes that went into effect in 2011, none of that was present.
So, but I guess I'm trying to figure out how that's a finding of fact. I mean, we have the economic impact statement, right?
There is an economic impact statement.
And we have what the act requires. And why isn't it just a pure question of law to ask, does this economic impact statement meet these requirements? And then I don't see where there's any further finding of fact.
If the economic impact statement is to assess the risk for the folks and to see who will bear the cost and how the cost will be borne, then that is indeed a question of law.
Counsel, the Court of Appeals said that the hearing officer and the Workers' Compensation Appeals Board were correct that they didn't have the ability to invalidate this schedule, which is what your relief asks for in this case. So we know they didn't have the authority. So what did those people do wrong that you think you have a KJRA ability to appeal, to seek judicial review of? I still don't get back to I gave you time to think about it. That's why I wanted to raise it with counsel first. How are you here?
And I do appreciate that inquiry. But what has happened in this case is that the Workers' Compensation Board has declined relief to Via Christi based upon a fee dispute by enforcing a regulation which has not been properly promulgated.
But it didn't promulgate that regulation. The Department of, or that schedule, it was published by a whole different legal entity, by the Department of Labor.
Right.
Okay, so take me through the KJRA that says you get to go to court and challenge the action of the Workers' Compensation Appeals Board. Which provision of the KJRA are you invoking in order to be in court?
Yes, sir. And I believe it's the provision that the agency action is unreasonable, arbitrary, or capricious.
But the Court of Appeals says that what this agency did, the Workers' Compensation Appeals Board, was correct because they can't do what you want done.
But what the Court of Appeals says is that the action of the board enforces an improperly promulgated regulation.
And it cited no authority for that proposition.
Other
That
than,
just, I mean, the Court of Appeals decision in this case sort of comes in and says, come on into to Uncle Judge here because courts are here to bring justice. And, you know, so this is an invalid regulation and we're just going to declare it to be invalid. Even though there's a whole different mechanism under the law to go declare these things invalid. I mean, I don't see how your action isn't required to be against the Department of Labor, because they're the ones who published this in the invalid manner that you're claiming. The Workers' Comp Appeals Board didn't do any of this.
they did not promulgate the regulation.
And they don't have authority to ignore the law to give you relief, do they?
There was a board member who dissented from the board decision and said, in reviewing a fee dispute, we are to determine the reasonableness of what has happened in that fee dispute. And when you look at the fee dispute statute, it implies that the board will have the ability to resolve the dispute. I argued at the time, you have the authority to order Paradigm to pay Via Christi. You can say this result is unreasonable, their reliance on the regulation is unreasonable, and you can order Paradigm to pay Via Christi under the fee dispute. But they said no, because to do that, we've got to declare a regulation invalid. We cannot do that. So good luck. And then our next step was the Kansas Judicial Review Act.
I've got 44-510J, which is the fee dispute
Yes, sir.
statute. Show me, which provision under this do you say that the appeals board has the ability to go against a published regulation, the rule of law?
There is nothing in that statute that says that, Your Honor.
Counsel, if I could follow up on Justice Biles' questions. The KJRA gives you, I think, 8 different ways to get into court, right, under 621C.
Yes, sir.
And you're making the argument under subparagraph 8, agency action otherwise unreasonable, arbitrary, or capricious, right?
Yes.
And in fact, Court of Appeals, I think it was in their last syllabus paragraph, while not reciting the statutory site, used the language that it was arbitrary and unreasonable, right?
Yes.
My question has to do with subparagraph 1, not subparagraph 8. If the rule was promulgated in violation of the statute, is it constitutional?
It is not constitutional.
Why not?
The Rules and Regulations Act requires that a regulation, a rule, and even an amendment, in this case, for which we are looking at an amendment to the stop-loss provisions, has to be promulgated in accordance with the Rules and Regulations Act. And this was not. To enforce that would deny Via Christi the due process.
And
for
there's
which
some law out there that talks about the authority of agencies to promulgate regulations is wholly derivative from their grant of power from the legislature. And they can't go outside that grant of power.
Yes.
So it would seem to me, at least you have an argument that if the regulation does not comply with that limited grant of power, it's unconstitutional. Was that argument ever raised? Am I bringing that up for the very first time?
The unconstitutionality, yes, I believe that this was the first time we've discussed this.
No, in fact, in your brief, you cite 4, 7, and 8.
Yes.
Okay.
Yes, erroneously applied the law or interpreted the law. And you're correct. Which leads me back to, we have a regulation that doesn't satisfy the requirements of the Rules and Regulations Act. We have a fee schedule that incorporates provisions that were certainly not intended. There's just no evidence that anyone in the division intended for these changes to go into effect in 2011. And then the board denies the relief that Via Christi seeks, applying that improperly promulgated regulation. Under those circumstances, the Court of Appeals has felt that it's unreasonable and arbitrary action. We certainly would agree with that determination and ask that this court affirm the decision of the Court of Appeals.
Initially, you started with this case, and are you aware of any other cases where this is in this time period that this issue has been litigated? Is this because of the amount is so substantial that that's why it's before us? I mean, have the other cases that have this question, clearly there's other cases that would have this question that arose in 2011. Did those just not go anywhere? It really doesn't matter. I'm just curious.
The division was unaware of any other cases that have proceeded through the fee disputes. The director at the time, Ann Hott, testified that other insurance carriers had contacted her concerning the change.
That's what led me to that. So what happened with those?
She said she told them it was not supposed to be there, and then her words were they complied.
Meaning they paid this 70%.
That was my interpretation of what she said.
Was there anything in the record that would indicate that the factual circumstances of those anecdotes are the same that would apply to Paradigm, where they entered into a contractual obligation with limits as to what's getting paid based on the schedule that was published and had the force of law? I mean, they just can't go ahead and start paying stuff because they've entered into a contract and they're getting paid based on how well they do at guessing how much these services are going to be paid and whether they can manage those services appropriately.
There does not appear to be another event that would mirror Paradigm's situation.
Any further questions? Thank you, counsel.
Thank you.
Again, and may it please the court, I wanted to address the concerns about the possibility that the fee schedule here and the administrative regulation then exceeding the scope of its granting authority under KSA 44510I. No one has argued that, and no one has demonstrated that the fee schedule in setting these competing pricing methodologies that 1 year it took the higher of them, the next year it took the lower, and the next year it took the higher, did anything that would be in violation of KSA 44510I. But I do agree with Justice Stiegel that if the regulation exceeded the grant of its authority under the statute, then it would be invalid to the extent that it did. But no one has demonstrated that anything in KSA 44510I was violated. I think the recitals that are contained in that statute talk about how the purpose of the medical fee schedule would be cost containment and to guarantee the availability of services. There's been no indication that there was any violation of that. And so I think that's part of our broader point, is that the whole purpose of the medical fee schedule is to place limits on how much a provider can charge for services rendered in the context of a work injury in the state of Kansas. And so in 2010, in this case, it became more restrictive than in other years, but that there has not been a demonstration of a violation of either the statute or the Constitution of the state of Kansas. I think what's important here, again, we're talking about a fee schedule that is dead and buried and has been changed, and we are the only case that apparently it affected. What the court does today will be more important in terms of setting forth standards of reliability for what occurs when people rely on a published regulation or a statute that isn't facially invalid. This fiat statement by the Court of Appeals that the economic impact criterion wasn't satisfied, when we have an NCCI report purporting to do just that, and the testimony of the people responsible for guaranteeing compliance with Chapter 77 saying that all of the steps were met, from the perspective of anyone looking at it, these formal requirements were met.
Any further questions? All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.